Kindly start, sir.
Hello, everybody. Good evening and welcome. This is the third in a series of conversations that has been organized by the Vidhi Centre for Legal Policy, along with the India International Centre. This is a series of conversations on constitutional law, where we are trying to bring constitutional questions of constitutional law closer to the people. A series of bridges and breaks. This is about the Constitution at a crossroads, and today's discussion will be about the Citizenship Amendment Act 2019 and its nexus with discrimination law, or the right against discrimination in the Constitution. So, about 2 years ago, we had a law enacted by Parliament, the Citizenship Amendment Act. The enactment of this particular law saw widespread protests across the country. It saw protests in various different regions by large numbers of individuals. In the popular resistance to this was largely to the legitimacy of the law, but it also was opposed by a number of individuals who did not agree on this question of legitimacy. And this disagreement about the legitimacy of the law seemed to largely split along political lines. And it's easy to say that the question of the CAA was politicized. But the crucial point here is that this disagreement, the critical point, this disagreement was not merely a disagreement, this politicization was not merely politicization of of the nature of ordinary politics or about everyday policy making. Instead, it was a question of constitutional politics. Those who were resisting the CAA were doing so in the language of the Constitution. There was one of the first times, at least in my lifetime, that popular constitutionalism was really manifested in the public life. And the questions that were raised, though they were raised largely about the law's constitutionality, it was unclear about how many people, how many of us who work on the Constitution, who work on constitutional law, who practice constitutional law in courts, actually engaged with this question. And it would be really strange if across the country, individuals were very concerned about what the Constitution meant, what its meaning was. They were very concerned. There were conversations happening at every family lunch table or dinner table about what the meaning of discrimination meant under our Constitution, and yet those of us working on constitutional law should remain silent on it. This would be quite strange. Or worse, if we were to presume that the answers were completely clear and did not require clarifying. And so that's why we are here today, to try and engage with this conversation, to try and take this conversation forward. There are a variety of questions that are raised by the law, but we are concerned with one particular question in relation with what the Citizenship Amendment Act, the CAA, has to do with discrimination, or what it means for the right against discrimination in our country. And as we go forward with trying to understand this subject, we have two panelists here, and I can't think of two better persons to be dealing with this question than our two panelists here this evening. We have with us Dr. Mohsin Alam Bhatt, who is an associate professor at the Jindal Global Law School and is also the executive president of the Center for Public Interest Law. He's written previously on the constitutionality of the CAA, and he's worked on questions of constitutional law and human rights. We also have with us Ms. Tulsi K. Raj, who is an advocate practicing at the Supreme Court and the Kerala High Court. She's also been an Equality Fellow with the Center for Law and Policy Research. She's been a visiting fellow with Rutgers University and with the Melbourne Law School, and she'll soon be a research visitor at the Bonavero Institute of Human Rights. Interestingly, Ms. Raj has also been involved in a litigation related with the criminalization of adultery under the Indian Penal Code, a question which was considerably involved with, which considerably involved the matter of discrimination on the grounds of sex. Those who are aware of the provision in the IPC that criminalized adultery, it was a provision that was that distinguished on the grounds of sex. So as we get started with this conversation here today, I wanted to open the floor first to Professor Bhatt. As before we get started on the conversation, and I'd like to point out to our viewers here, the audience here today, that the subject matter is quite diverse. It can be quite complicated at points. and it would be great to have your patience in trying to get through some of the more the nitty-gritties of these subject matters. But as we get started, it's important to realize that the immediate impetus that the public discourse on the CAA seem to be largely focused on this question of religious discrimination, about discrimination taking place on the grounds of religion between members of different religions. But the larger context, the background out of which this law emerged, the CAA, is also very significant, because any question of discrimination isn't merely a question of discrimination on the ground itself, on the question of which is the ground on which discrimination is taken place, or the ground on which people are being distinguished from each other, but also as significant is the question of what is the subject matter on which the discrimination is taking place, or what is the benefit, the resource, or the right that is being allocated or distributed in a differentiated manner. And this is what, Professor Bhatt, I'd like you to walk us through a little bit, to give us a little context about what exactly is at stake when we're talking about discrimination on the question of citizenship. Professor Bhatt.
Lalit, it's a pleasure to be speaking to you and through you with everybody else in the audience, and really wonderful to share the panel virtually with Lucy. So what I thought I'll do is just to take a few minutes to lay down in a very preliminary fashion the legal politics, as well as sort of the systemic nature of CAA, because as Lalit, you rightly pointed out, the CAA should not be seen in isolation. There's obviously a larger question of citizenship, but also CAA is deeply linked both in terms of the law itself, but also institutionally and socio-politically, with a large number of other moving parts in the contemporary state of citizenship policies in India. And in doing so, I would like to raise 5 preliminary questions. I may not have time in responding to your question by laying down clear answers, but hopefully these preliminary questions will benefit everybody who's listening, and we can take them up if needed subsequently in some sense of a broad architecture of puzzles and questions. And one of the things that I would want us to appreciate is that these questions raise rather troubling concerns, both about the nature of India's constitutional citizenship, but also alienage under the constitution. And by alienage, I mean non-citizens within Indian territory, and what are they entitled to under the Indian constitutional scheme. So the first element is CA's connection with documentary citizenship. CA is not isolated, but part of a larger trajectory under Indian citizenship law, which has resulted in dismantling of birthright citizenship, or what we lawyers call jus soli regime, and also introducing a fair amount of citizenship insecurity and unsettling the stability of citizenship status. And in order to appreciate that, I think we'll need to see CAA not in isolation as something that happened in 2019, but particularly, for instance, in relationship with the 2003 Citizenship Amendment. The 2003 Citizenship Amendment introduced the category of the illegal migrant. And in other words, that meant that anybody who is an illegal migrant did not have any route to citizenship, either through registration or naturalization. And of course, as we know, CA 2019 reduced the ambit of that exclusion of the illegal migrant under the 2003 amendment. Now, one of the very important implications of the 2003 amendment was to make the status of citizenship contingent on its determination under the immigration law of India. And immigration law includes enactments like the Foreigners Act, and of course, the famous Foreigners Tribunals. And what essentially this does is that it makes the citizenship status of a person contingent on how, under the foreigners regime, under the immigration law, the citizenship status will be decided. And this is done through processes of documentary evidence, among other things. And as many of you would already know, this has wreaked havoc in places like Assam, where foreigners tribunals have, for instance, already declared in the approximation of around 100,000 people as foreigners, often on minor documentary discrepancies, on minor variations in documentary evidence, often rejecting oral evidence. And of course, NRC, where 1.9 million people are now the verge of statelessness is one manifestation of that, those sort of pathological consequences of documentary citizenship. Now, in other places, I have called what these documentary regimes do irregularization of citizenship. And what I mean by irregularization is when the state uses insidious and complicated legal processes, often in the name of national security, to not revoke citizenship of people in any formal manner, but by suspending that citizenship, by introducing severe uncertainty of citizenship status. So for instance, the people who have been excluded from the NRC are not formally non-citizens or formally foreigners. They do technically have the right to appeal to foreigners' tribunals. But we do not know when that appeal process will start. And for the time being, that essentially means that everybody excluded from the NRC, or for that matter, all these people who have been declared to be foreigners by the foreigners' tribunals, their citizenship status is in some state of suspended animation. Now, specifically in relation to discrimination law, I think it has some really serious implications. The obvious implication is who are the people, which groups are most susceptible to the irregularization of citizenship. The experience from Assam shows that particularly when it comes to women, transgenders, of course, Bengalis in Assam, or even Muslims, they are much more susceptible to irregularization, either because they may not have the requisite documents, or there is a system in place, there's a systemic bias or prejudice, which would end up targeting them rather than the others. So that's the first issue I wanted to talk about. The second is, which we often forget in our at least popular conversations around citizenship, is the impact on child rights. Now, one important implication of reading 2003 amendment with the 2019 amendment is how children who may be born in India, even to one Indian parent, lose their right of birthright citizenship, which essentially means that children who are born in India, even to an Indian parent, if the other parent is deemed to be a foreigner by the state, may actually be born into statelessness. Now, this is an obvious problem for the question of citizenship in India, apart from the fact that it is a clear violation of India's international obligations. Under Child Rights Convention, India is bound by the obligation of securing the right to nationality of children, which is clearly being violated because of the 2019 and 2003 citizenship amendments. And of course, one can think about implications for our own constitutional scheme. Article 21, in any sort of fair reading, would be violated because of this impact on children. The third implication is privacy and personal liberty issues that arise because of 2019 amendment and how it fits with the larger trajectory of citizenship policy. Now, because of the 2003 and 2019 amendments, Indian parents do not have the ability of passing on their citizenship to their children merely by virtue of the fact of who they had children with. In other words, if their partners are deemed to be illegal migrants under the immigration law in India, then they cannot pass on their citizenship to their children. Now think about it. As in, at one level, this appears to be an indirect interference by the state in the lives of Indians as far as their decision of who they want to be married to, who they want to have children with. These are clear privacy concerns that current citizenship law raises. The other implication is for the integrity and security of family life. If the children of Indians are exposed to irregularization or vulnerability of citizenship status, potentially even detaining subsequently after being declared to be a foreigner, this has obvious implications for Article 21 and the right to privacy as well as right to have a family life. The fourth issue very quickly is the rather troubling problem of alienage. So as I said, the problem of alienage is how should we, or for that matter, any constitutional system, deal with non-citizens in the territory of our country? What kind of rights do they have? What kind of obligations do they have? And the larger story of Indian constitutional law does not really reckon with this rather challenging question of alienage. Now, the CA 2019 did not create the problem of alienage in India, of course, but it aggravates it. It aggravates it by creating processes of irregularization, by entrenching documentary regimes, by declaring certain people as foreigners or not giving people citizenship status, excluding them from any route to citizenship altogether. And one of the most puzzling questions, which we haven't resolved, and I hope we get to resolve and start having a conversation about, is what are these people who will eventually be declared to be non-citizens entitled to under the constitutional scheme? So one story we tell in our constitutional law sort of folklore is this evolution of Indian constitutional law towards this golden triangle of 14, 19, 21. That equality, which by the way, Article 14 is applicable to everybody, citizens and non-citizens. Then Article 19, which is only for citizens, liberty, rights, and Article 21, right to life, which is also applicable to everybody. But this idea of these three, this triangulation of these three wonderful provisions generated so many substantive and civil political rights, including right to dignity and privacy. But our jurisprudence has not reckoned with how do aliens fit in this triangle. And what I suspect may eventually happen is there will be a segregation of those three famous typologies of citizenship, the social, civil, and political citizenship, where perhaps we'll move towards a world where while aliens may be guaranteed social citizenship, but they may be excluded or partly excluded from civil and political citizenship. Now, these are troubling questions. We don't have a clear answer to it. But I suppose the sooner we start talking about it, the better it is. And it has obvious implications for discrimination, because perhaps we are moving towards a world where discrimination in social rights may be unacceptable, but certain kind of discrimination and exclusion when it comes to other rights may seem to be more acceptable. I have my own views on the matter, but I think we should just appreciate how these irregularization policies, which CAA 2019 is a central facet of, results in really destabilizing how we have imagined our own constitutional jurisprudence. And finally, the question of religious discrimination, and very quickly on it, because I do not need to rehearse the conversation around rather the direct form of religious discrimination which CAA 2019 deals with. Though I would like to say a couple of things. The first is that while it is clear that CAA 2019 directly engages in religious discrimination, what is implicated in that question is the more fluid and highly contested question of constitutional identity. As many of you may know, this distinction between who's a refugee and who's a migrant is historically deeply embedded in the way Indian citizenship law has evolved since partition, where non-Muslim or Sikh and Hindu migrants coming from, say, West Pakistan or East Pakistan historically were absorbed and given recognition as citizens, whereas it was much harder for Muslim returnees to come back. And this is sort of an old story which historians like Zamindar and others have talked about. And therefore, this is fundamentally a question of constitutional identity. And constitutional identity is never cast in stone. It's not static. Constitutional identity is constantly evolving. And that is why I would like to go back to Lalit's initial comment about the protests that happened on the streets. Constitutional identity is the result of constant popular articulation of constitutional values. And this is something which we can't let go of. And this will be fought both inside and outside courts. Is our constitutional identity wedded to a certain ideal of secularism where citizenship can never be determined or should not be determined based on religious identity, which will remain in tension with how citizenship in India has actually evolved? Or will we move towards a wholesome sort of formal endorsement of what has historically remained implicit in the evolution of citizenship policies? And the other thing, which again, before ending, I would like to point out as far as the systemic implications of religious discrimination are concerned, is what I fear policies like CAA 2019 in conjunction with things like 2003 Citizenship Amendment result in is creating what historian Nye calls alien citizenship, where there are certain groups of people who may formally be citizens in the country, but they are racialized groups who are understood to be outside the nation itself. They are vulnerable to arbitrary state action. Now imagine a world where certain communities or certain religious groups or ethnicities are always suspected to be foreigners, always expected to prove their citizenship, and therefore will always be vulnerable to arbitrary state power, even if they may be formally citizens. And I fear that's what the implication, political implication of the 2019 Citizenship Amendment Act is, that certain people are understood to be part of the nation and others are not. And there are obvious, tangible consequences in terms of arbitrary state power. And the question of citizenship has then to be put and situated clearly within those sort of cultural, constitutional, and social implications of what we'll see will unravel if we give up that battle of constitutional identity. I'll stop here, but hopefully we'll have a longer conversation after this.
Thank you so much, Professor Bhatt. And it's really interesting that you have laid out so many different aspects of this particular law for us. And it's important to remember that though we are talking about a question of how the CAA, what the CAA means for India's, the future of India's discrimination law, that there are other very significant questions, other than the questions that have really gripped the public's imagination. People are generally very concerned about religious discrimination, but that isn't the only significant question or the only significant constitutional question involved. And I think that's very clear. Mr. Raj, as I move to you, I wanted to just highlight some of the points that Professor Bhatt has made. In relation with discrimination, he really brought out these two different kinds of discrimination that you were really, referring to. On the one hand, he was talking about how many vulnerable groups are affected by a process like the NRC, which is the background for the CAA. They're affected by it in different ways. Even if there is the general neutral looking law or a provision which is doing the verification of citizenship, it can affect people in different ways. That's one way in which one can think about discrimination. And on the other hand, you're also talking about the very explicit use of the religion as a ground in distinguishing how accelerated routes to citizenship can be granted to people. So that second point especially, as well as the first point perhaps, how would you say that interacts with the Constitution's promise for a right against discrimination? The Constitution says that you're not supposed to discriminate. The state is not supposed to discriminate against citizens on grounds only of religion, race, sex, caste, these kinds of grounds. And it says that it's only for citizens. And would you say that India's discrimination law is ready for this question? Has it already developed to a stage where it can answer this question? What really does it have to say about this?
Thanks, Lalit. And again, I'm very glad to share this panel with Mohsin and you. So it's an interesting question, and this question has been raised not only by sort of so-called right-wing politicians, but legal scholars as well. And they've written across journals and newspapers that Article 15 argument is not an argument that is available to the persons who are challenging the constitutional validity of the Citizenship Amendment Act because of the text of Article 15. That Article 15 itself says that it's applicable only to citizens, and then the point sort of stops, that you cannot go anywhere from there because Article 15 says citizens, and from there you can't make any further argument. And the problem with this argument, as it will be evident to many of us who have been engaging with the Constitution for a while, is that it does not understand the core of the value of equality as enshrined in Articles 14 and 15 taken together. It does not understand that fundamental rights are not to be treated as watertight compartments, as recently held by the Apex Court in a series of decisions, including Navdeep Singh Johar. It just looks at Article 15 in isolation, as if everything else in Part 3 of the Constitution is separated and isolated and divorced from it, which is just not the case. We have the Golden Triangle jurisprudence, which, as Mohsin was rightly pointing out, and we have the jurisprudence which is evolving recently, that equality is supposed to be something that is supposed to be interpreted by looking at the constitutional provisions in close scrutiny and by looking at them together. What happens when we look at them closely is that we see that it is a composite code of equality that the Constitution promises. It's a very important doctrine, and it's a very important ideal that the Constitution promises. And I believe that every legal doctrine, including the doctrine of non-discrimination, has a moral reason behind it. There is a moral wrong of discrimination. that the Constitution wants to prohibit. And of course, many people will disagree on that, on the interaction between law and morality, but I strongly believe that constitutional provisions, especially rights provisions, have an underlying morality. And this, if you look at what the Equality Code seeks to protect, what it seeks to prohibit, we will understand the fallacy of the Article 15 argument as a standalone argument. The problem is that Article 15 does not have an independent standing of its own. It always goes together with Article 14. And Article 14 is, of course, not limited to citizens. It applies to all. It will apply to every person who is in the territory of India against whom the CAA or any other legislation for that matter seeks to impose itself. And that is precisely why you have Article 14, which is essentially a catch-all provision, which it could not have been phrased broader because it says equal protection of the laws and equality before the law, which and you could take in anything in equality. You could take in indirect discrimination under equality. You could take in intersectionality within equality, and there is of course multiple areas of law which is essentially taken in within the concept of equality. And slightly derailing from this question now, I will try to make one preliminary point which I wanted to make. And that is the distinction between political equality on the one hand and the legal doctrines of equality and non-discrimination on the other. One thing which I think we as lawyers and legal academics tend to forget is that equality is also an important political ideal. It is, of course, found in law, in the Constitution, under Articles 14 and 15, but it's also a very significant political principle. And part of the protest against the CAA, which we saw in the streets, was, and of course, some of them were, of course, holding the Constitution and holding the preamble, but it is also a manifestation of the fact that equality is something that the state is supposed to give, even without invoking the provisions of non-discrimination. Of course, questions of Articles 14 and 15 will come before the court and will be adjudicated, hopefully if and when the Supreme Court takes up the challenge against the Citizenship Amendment Act, which many of us are not hopeful about, but yeah, that remains a fact. But as a political ideal, we need to see what the CAA does. And this distinction is important because all legal questions do not subsume or they do not exhaust the political question. The Indian government remains accountable politically to citizens and non-citizens, in fact, persons who are situated within the territory of India, to explain why a particular religious community, only on account of religion, has been excluded from granting a benefit, namely citizenship under the CAA. And that political question, we need to understand that is a separate legal question which the government needs to answer. And it's important to think that it's important to think that the question of politics is not fully taken over by the legal questions, and that is why the Supreme Court is in fact wrong in asking the question as to why the farmers are protesting in the streets when the Supreme Court has already taken cognizance of the constitutional validity of the farm laws. The court is simply wrong because the court thinks that all legal questions subsume or all legal questions contain political questions, which it does not. Politics is, of course, operating on a larger frame, and the court essentially needs to leave that out of its legal confrontation of engaging with, let's say, Articles 14 and 15. Now, coming back to your question, I do believe that Indian jurisprudence has evolved with the recent decisions, including of the All India, the Sabarimala judgment, the Navtesh Singh judgment, the Joseph Shen judgment, and Nalsa, that it has tried to look at the moral value of discrimination. That's what it has tried to do in the recent decision, and it has done so rightfully. And Justice Chandrachud, when he asked in Navtesh as to what is it about all these grounds, what is it that makes certain groups protected under the Constitution, then the court is essentially answering this question of what is the moral reason behind the prohibition of discrimination. Why, as a matter of morality, why do we have an ideal called equality? Why do we have an ideal called non-discrimination? And then it came to at least one of the answers for this question is that certain groups are deserving of protection, are entitled to protection, because two criteria are attracted. One, the trait on which they are discriminated is a trait which is immutable, which cannot be changed. The second is that this particular trait on which you're discriminated against is a matter of fundamental choice. It's essentially an innate part of your personality. It's an important part of your personal identity. And it's something that you've chosen voluntarily as part of your autonomous integrity. And these are the two aspects, according to the Supreme Court, and rightly so, which underlie the grounds in Article 15. And that is the core which underlies the grounds of non-discrimination under any constitution or any charter of human rights for that matter. And if you look at that, we see that religion is something that can, in fact, fit both the criteria in some way or the other. It depends on how you want to interpret it. But I would think that most of us would accept that religion is either a matter of fundamental choice or it is a matter of immutability. It depends on how you want to define immutability, because it's not something that can never be changed, because you can always ask the question, of course, you can convert, and then how does religion become something immutable? And the answer to that is that immutable should be understood as something that will impose upon yourself very high cost for changing it, and that is something that can be conceived as immutable. And it, in fact, fits the bill under both these criteria. And that is, and then you understand that there is a reason why religion is prescribed as a criteria for non-discrimination, both when we read Articles 14 and 15 together. And that's the sort of partial answer to your question. And another aspect which also I want to clarify or perhaps make a second preliminary point is that we should understand what the CAA is about. And we should, of course, not understand it in isolation, as Mohsin was rightly saying. We should understand that the problem imposed by the CAA is not a mere problem created by the CAA by itself in 2019, that it has a larger framework, and that larger framework is a framework about refugees, framework about foreigners, framework about illegal immigrants in the country, for which in India there is very less legal protection for aliens or so-called foreigners who are not citizens, who are in the Indian land. And India has conveniently also not been a party to the Refugee Convention, and has been consistently saying that the principle of non-refoulement does not apply to it under the international human rights law and under the Refugee Convention of 1951. And there is and that is the pre-CAA context and the pre-CAA situation. And there's also a post-CAA situation or context, which is, of course, a problem aggravated by the NRC, which is currently put on hold and is limited to Assam for the time being, but which people at the government level have continuously announced that there is a plan to extend the NRC to a national level. And then we see how CAA and NRC operate together. We see what is this regime trying to do. We see that it's a regime essentially attempting to, in the guise of granting citizenship through the CAA, while simultaneously trying to create a national register of citizens. On the other hand, what it tries to exclude and who it tries to exclude. We see that some people are considered to be, or attempted to be considered to be, second-class citizens, and that is what the CAA essentially wants to do. And by doing that, it violates, in fact, all known values of non-discrimination. It offends all the principles behind why discrimination is prohibited. And that, going by both by philosophical and legal theoretical reasons of the values of non-discrimination that it offends, and on the second limb, going by the Indian jurisprudence on non-discrimination, I think the CAA fails on both counts, and that is the fundamental problem with that. And it offends both the political value of equality on the one hand, and is unconstitutional for legal reasons on the other. I will stop with that now and then see how the conversation goes. Thank you.
Thank you so much, Ms. Raj. And thank you especially for mentioning that there are instances where the Supreme Court has mentioned that when a matter is before it, when it is sub judice, so to speak, when it is, when it is already supposed to be hearing a matter that others need not be mentioning or talking about it, because that's precisely what we are doing here in a way. We don't intend, of course, to answer the question conclusively about whether a particular law is constitutional, but I would say it's, we'll be absolutely guilty of negligence if we don't try and take forward these conversations, try and clarify them as people working in constitutional law. I was especially caught, though, by how you were describing the core value behind discrimination law, about the way in which the Constitution has chosen these particular grounds, right, like race or religion. And you've mentioned these 2 points about a fundamental choice that an individual makes, which is often how people talk about religion, or something that is immutable, something that is a trait of yours that is very valuable to you, but that you did not have a choice in making, or in, incorporating within your identity. You didn't really choose it, and therefore punishing you because you have that trait essentially is a cost upon you. And it's interesting because this is sometimes people suggest that this means that discrimination law is not so much about equality as it might actually be about liberty. Discrimination as a concept isn't so much about making people the same as it is about preventing them from being subject to certain kinds of limitations because of things they didn't choose themselves. So that's very nice to hear this particular this particular aspect come forward, so that individuals can understand it. But the question nonetheless arises that our polity, our government, the scheme of governance, does generally in many areas engage in distinctions and classifications on grounds that are listed in Article 15. And some of these distinctions aren't really excused, explicitly justified within the Constitution itself. And yet we seem to be engaging in those kinds of distinctions. I would want to get back to you about this particular point, because it would help us really understand the core of the disagreement that is going on in public minds. But how is it possible that the country can engage in distinctions on grounds listed in Article 15 for certain things, but then they'll have such a big problem about it being enforced in certain other areas? But just for a moment, because it will be important for us when we go into that question, just for a moment, I want to turn to Professor Bhatt, and I want to ask, sir, when we think about a measure, a governance measure, a policy which wants to be making distinctions in this way, we are immediately caught by the question, which all law students learn, is supposedly very fundamental to questions of equality, which is that if you classify between individuals, you're supposedly doing so because of some reason. And as long as the distinction actually furthers that reason, that government objective that you're trying to achieve, then that should probably be fine. In the question of the right to equality, it's not actually unequal to treat people differently for things that is relevant to that treatment. So I want you to try and help us understand what really is the government's legitimate objective here in trying to say, first, in the first instance, verify the identity of citizens, verify citizenship per se. Is there some legitimate objective, or would it be radical? It would be entirely a radical prospect to suggest that governments should not be so concerned in verifying citizenship? And secondly, on a second leg, what is the government's objective really in trying to accelerate the citizenship or the naturalization of individuals from certain religious groups on the grounds that they have suffered religious persecution? What does it mean? How are they going about formulating their objective? Because understandably, as the petitions are in court, they will be trying to formulate some kind of an objective. It would be good to have a fix on that objective and try to understand whether there is some change in the outcome of the constitutionality of the CAA depending on how we define the objective of the law. Professor Bhatt?
Thank you, Lalit. There are 2 or 3 related questions in what you've said. I may not be able to address all of them. In case I miss out, you could just let me know. The first rather difficult question you asked was, what is the purpose of the state, quote unquote, verifying citizenship? So I imagine what you mean by that is, what is the purpose of instituting policies like foreigners tribunals or other documentary regimes like the NRC, and how do they fit with the constitutional scheme? I may not have a full-fledged answer to this question, but I'll share some preliminary thoughts. See, what the Indian state has basically said, and that, that got passed on to what the Supreme Court did when it initiated the update of the NRC in Assam, was one sort of formulation was that all sovereign states have the right, perhaps an obligation, to know who their citizens are. And once we accept that understanding, then there cannot be any constitutional objection. In fact, it's quite the opposite. There must be a constitutional mandate to have a list of citizens. Formulated like this, I don't think any reasonable person would disagree, right? But I think I would have two preliminary notes of caution. The first note of caution is that if we look at the history of documentary regimes of citizenship in India, they have not resulted from a rather easy or let me say an innocent concern about creating a list of citizens, which any sovereign state should do. The NRIC, the National Register of Indian Citizens, was not even legislated. It was introduced under the 2003 citizenship rules by the government. This is the same amendment in 2003 which introduced the category of illegal migrant. And if you study how the citizenship rules incorporated the question of documentary citizenship regimes, we'll discover that the primary purpose seemed to have been national security. Over the last 3 to 4 decades, there has been a growing paranoia around the perceived threat of quote-unquote illegal immigration, disrupting the national security and demographic balance of the country. So rather than documentary regimes trying to create what may appear to be a rather straightforward, legitimate exercise of citizenship enumeration, documentary regimes were introduced in order to isolate citizen from non-citizen on the ground of national security. These were considered to be these exceptionalist measures, which is very similar to what the Supreme Court did in 2005 in the Sonowal judgment. Some of you may know, until 2005 in Assam, citizenship determination used to happen under the tribunal set up under the IMDT Act, 1983. And these tribunals had a lot of due process protection because the primary concern was that genuine citizens of India should not be targeted or harassed. So there should be judges who hear these matters, there should be due process protection, procedure should be there should be an appeal process, how tribunals work in this country ordinarily. In 2005, the Supreme Court struck down the IMDT Act and basically said that immigration into India and immigration into Assam was a form of external aggression. And there are all these terrorists who are coming into the country, and therefore we need to create this highly deferential regime based on executive fiat, where the burden of proof is shifted to the individual rather than the state. And these foreigners tribunals, which practically have no procedural protection, should have the authority to decide the status of persons. If you look at the parliamentary or policy debates around the same time, the NRC or NRIC was meant to do exactly the same thing from the other side. So rather than identifying suspected foreigners and subjecting them to these rather objectionable procedures, objectionable because of lack of due process protection, the idea was to create a documentary regime to do it. And I think that should introduce some amount of skepticism in how we understand policies, documentary policies like NRC, among other things, that they are not straightforward, innocent policies of creating citizenship enumeration. Now, the second aspect of it, obviously, is what I've already mentioned, which is the indirect discriminatory impact on certain people. When in our country, people do not have any viable or meaningful guarantee of IDs, where vulnerable groups like women, who are more likely to be married younger, who are less likely to be educated, less likely to have properties, and hence less likely to have documents. What kind of country are we talking about when we mandate documentary regimes of citizenship? It's inevitable that there will be exclusion. And the problem of indirect discrimination there, which now is part of our constitutional jurisprudence, is rather obvious. It's obvious that it will have indirect discriminatory impact. The second question which you asked, I think what you were saying refers to the problem of reasonable classification, a typical test under Article 14. The idea is that if there is a state purpose and the classification is done on the ground which justifies that purpose, then that classification should be accepted. Now, there's a long history, and Tulsi can also sort of step in to tell us various reasons why this particular test has not been satisfactory. It's a very formal test. It does not really protect people from actual discrimination because it doesn't place any meaningful requirements on the state to make sure that there is no discrimination. But as far as CAA is concerned, and once we put CAA 2019 in the larger sort of trajectory of Indian citizenship law and policy, I think it becomes clear that the implications of CAA 2019 is not only on the migrant. The implications of CAA 2019 read with 2003 Citizenship Amendment is on people who are born in India. It's on people who are Indian citizens. So therefore, it is on not just people who are just moving in. It is also for the people who are not moving in, who are not migrants. So the implication of CAA 2019 would be to render them stateless, to render the children who are born in India stateless because of certain discriminatory policies. So a formalistic understanding of classification and non-discrimination, which is typically associated with Article 14, is unviable, both for reasons that Tulsi mentioned, which is that 14 is deeply integrated with the larger policy of non-discrimination and 19 and 21, among other things, but also by the fact that this is not only dealing with people who are migrants, but also people who are non-migrants, who are in India, who are born in India, and who are Indian citizens. And therefore, that formalistic formula has to be rejected.
Thank you so much, Professor Bhatt. The suggestion that you made that we consider this question about what the legitimacy of this test is under Article 14, the reasonable classification test. I'll turn to Ms. Raj about it, but just to make it clear to the audience, this is somewhat the distinction that this public discourse has really brought out. It's really made salient for everybody in the country to realize. It's often difficult to understand what it means unless one talks to somebody who's studied constitutional law, even at law school. There tends to be, in traditional constitutional law, so far at least, this very strict distinction between how things are to be treated if they are covered under Article 15, which is the right against discrimination. That right which says that you should not be discriminated against on the grounds of religion, race, gender, etc. And the other right, Article 14, which is considered the general right to equality, which says that all persons are going to be have the benefit of equal protection of the law. That's just the right to equality. The distinction has become immediately clear in this context because Article 14 is available to all persons, including non-citizens, while Article 15 is supposedly restricted only to citizens because it says citizens as a as part of its language. So I'll turn to Ms. Raj. Do you think that what really would be the result if the Supreme Court, when it considers this question, if they apply the reasonable classification test to this question, the different kinds of distinctions that the CA and RC process creates, what really would be the result? Would it be a good thing if that is applied, or is there something strange about applying the reasonable classification test to a question of discrimination? And just an allied question with that, why exactly does Article 15 only provide the right against discrimination only to citizens? Was this some kind of a failing on the part of our constitutional framers? Was there only a limited reason to allow for discrimination on the grounds of place of birth? What really was going on here? And does it mean, for example, that the government is free to discriminate on the grounds of sex, on the grounds of religion, on the grounds of race against all non-citizens? Can they treat Australian women and Australian men the same? Is that what it means?
Thanks, Lalit. So I'll first try to answer your first question. So of course, in India, which we have learned as students of constitutional law, it is in fact page 1 of the constitutional law textbook about the traditional test, the twin test, as I will call it, of intelligible differentia and rational nexus. So what the test essentially says is that the classification that the state is making with respect to a particular state policy, be it citizenship or anything else, or a state legislation such as the parliamentary legislation such as the CAA, is that there should be the classification that the first limb is that there should be an intelligible differentia that the state is trying to make, and there should be a rational nexus with the objective of the legislation. In this case, whatever the objective the Indian government wants to present, it should have a nexus. This aim should have a nexus with the classification that the state has made. Now, the problem with the CAA is that we have thought of all possible reasons that the state can bring on. We've thought of all the possible aims and objectives which the state can project, and we see that none of these objectives are fulfilled when it comes to the CAA. So one of the arguments which are made by people who are in favor of the constitutionality of the CAA is that what it wants to protect is religious persecution. And the moment you launch religious persecution, you understand that only religious persecution of certain countries are listed in the CAA. So if you look at, and if you go back to the basics, and if we go to the Amendment Act of 2019, it says, and I read, provided that any person belonging to Hindu, Sikh, Buddhist, Jain, Parsi, or Christian community, so that's the first requirement, that you belong to one of these communities. And again, from Afghanistan, Bangladesh, or Pakistan, so 3 countries are illustrated, who entered into India on or before the 31st day of December 2014. So thirdly, there is a cutoff date. These are the 3 requirements that you need to prove if you need to avail the benefit of the CAA. Now, the first question is, of course, why these groups and why these countries? Why these religions and why these countries? And if we, the first answer that is brought out in the sort of guise of benevolence is that it is religious persecution. And if religious persecution is the bona fide answer, and if that is the objective which the state brings forth to fulfill its obligation and to fulfill the test, the twin test under Articles 14 and 15, then we see that other groups who are facing religious persecution are just excluded from the purview of the Act. We see that Rohingyas, who are in fact one of the most persecuted community in the entire world as recognized by the United Nations and international human rights organizations, are excluded because Myanmar is not one of the countries which the CAA wants to protect the people of. Therefore, the question of religious persecution, now the state is not really able to justify that it is because of religious persecution that we have brought in CAA. Now, the second reason that the state has purportedly set, or the state might make in the CAA arguments before the Supreme Court, is that we are trying to protect people, minorities of countries, where the states have a state religion. So Pakistan, the state would argue that has a state religion of something of that sort, and hence we want to protect the minorities of that. But we see that there are also other countries which are in India's neighboring countries, such as Sri Lanka and Nepal, where certain religions are akin to state religions, and where religions in fact find an explicit mention in their constitution, such as the Sri Lankan constitution. And we see that some exclusion of countries like Nepal or Sri Lanka is not justified under this account as well. So the second reason, or the purported reason of the state, also fails. The third reason that the state that might come forth is that we want to protect communities, we want to protect people of countries which were part of British India at some point. Again, we see that due to the exclusion of, since there is, Afghanistan is included in the list of countries that I mentioned in the CAA, we see that that also does not really align with what the state wants to achieve. So in fact, I think that although I believe that the recent jurisprudence on discrimination law has been a fantastic contribution to constitutional law and jurisprudence, I in fact believe and slightly perhaps disagree with Mohsin on whether the classification is, or whether what the CAA proposed to do is violative of the traditional caste itself. I believe that even without going to arbitrariness, under Shahara Banu, which is propounded by Justice Nariman and recognized, so on and so forth, even without going to indirect discrimination, even without going into expressivist account, which is somewhat of a doctrine which is laid out by Joseph Schein, even going under the traditional twin test itself, the CAA just manifestly fails because state is unable to project any reasonable objective under which it has enacted the CAA. And this requirement, I believe, is a strong requirement even under the traditional twin test. And if the state is saying something like, we do not have a reason, we just include countries because we deem them fit, that is insufficient for the purpose of fulfilling the obligation under the traditional twin test. So I think that even under the twin test, the CAA does not hold water. And on that ground alone, the CAA is bound to fail. I think there are multiple reasons of attack. There are multiple grounds by which CAA is bound to fail, and the traditional test is again not satisfied when it comes to the constitutionality of the CAA. On the second question, of course, it's a historical question as regarding the inclusion of 15 inclusion of 15 and its so-called limitation or confinement to citizens, and I do not have a ready answer for that. I believe in the Constituent Assembly debates, there has not been an explanation or a justification as to the limitation to citizens with respect to Article 15. But I believe that one of the reasons for doing that is essentially constitutional interpretation, right? What kind of interpretation do we want to adopt to the Constitution? If we want to look at provisions in isolation, we want to look at the ideal of equality, and the latter is what the courts have been trying to do in recent times. And this perhaps might have been one of the motivations for the makers as well to put in Article 14 for a very express reason and to leave it as open as it possibly could. And it then becomes evident that by a joint reading of 14 and 15, you essentially cannot, the state is failing to pass the constitutional test under the CAA. And I would believe that would, in fact, speak in favor of the petitions challenging the constitutionality of the act. But yeah.
Thank you so much.
If I may just say one thing a little before. So I completely agree with Rishi. I do not claim that CA would in any obvious manner satisfy the reasonable classification test. In fact, I think it does violate reasonable classification test. But I do think that reasonable classification test is not a strong enough ground. And for the two main reasons, interrelated reasons. The first reason is that in what appears to be the case is that the government is arguing not just that it meets reasonable classification test, but its argument is fundamentally linked with Article 11 of the Constitution, which in their interpretation, which is perhaps is a fair interpretation, that under the Constitution, the Indian Parliament has a sovereign authority to determine the qualifications of citizenship. Now, that is something which will definitely be argued in the court, and therefore we look forward to it. But it is not fundamentally unfair to argue that Article 11 may be very permissive and give the authority to Parliament to determine the qualifications or disqualifications for citizenship. The second thing is that the jurisprudence of reasonable classification under 14 is quite diverse. And what the government is relying on, which should be relying on, I suppose, is to really rely on that part of reasonable classification jurisprudence, particularly in economic regulation cases, where the courts have been quite deferential to the government deciding the purpose of the law. So, for instance, a counterfactual would be that the government would just argue that under Article 11, we do have the power to determine who to give citizenship. And we have decided that we wanted to give citizenship to certain religious communities coming from Pakistan, Bangladesh, and Afghanistan. That is our purpose, and we are authorized under Article 11. And the classifications which we have subsequently made fit with that purpose. The problem with reasonable classification test is that in and of itself, it does not provide us tools to judge the correctness or incorrectness of the purpose itself. And that is where a lot of this litigation will fall on. And that's the whole question of constitutional identity and secularism. But definitely reasonable classification is an important tool in the repertoire of people who are challenging these laws. The second element which we haven't talked about is the question of indirect discrimination. And I think we should just sort of, if nothing else, just flag it. Because recently the Supreme Court has, in a more sort of wholehearted fashion, endorsed the indirect discrimination test. And from my reading of it, what the court has basically said is that if in context of systemic disadvantage against certain groups, even if the state makes laws that are facially neutral, that do not explicitly make any distinctions based on identity, but because of those classifications, there are indirect or disparate impact on certain groups, which place an already marginalized group in a worse off position, that further entrench or aggravate conditions of systemic disadvantage and discrimination against a discriminated group, then the court would be critical towards it. Of course, then there would be some amount of sort of proportionality kind of balancing analysis. The court will see whether it was a rational law, whether it is a necessary law or not. But this is sort of, in some sense, the foundation of indirect discrimination jurisprudence. And one of the things which is really important for all of us to consider, and hopefully the court will consider, is how the cumulative impact of the 2003 Citizenship Amendment and 2019 Amendment leads to indirect discrimination, not only against Indian residents or Indian citizens, but also incoming migrants. So the category of illegal migrant does not recognize or is not sensitive or not attentive towards the problem of asylum seekers, of refugees. Of course, we have not signed the Refugee Convention, but refugees in any case are a disadvantaged group, or the stateless, for instance. All of them are clubbed together as foreigners or as potentially illegal migrants. And I think an argument can be made and should be made, and which I would endorse. In a preliminary fashion, it can be stated that, say, for instance, Rohingya refugees, they are here because of ethnic, religious, racial discrimination. They are a racial group. If they are clubbed together in a larger category of quote unquote illegal migrant, and then their children are also not given the right to citizenship, they are not given any right to citizenship through naturalization and registration, even if they stay here for a very long time. This is a relatively clear case of indirect discrimination against these groups. But again, going back to my preliminary observations, this question, whenever it is decided, will require all of us, and courts in particular, to consider the problem of alienage under the Indian Constitution. What are non-citizens? What are aliens who are in our territory and subject to states' coercive powers entitled to under the constitutional regime? Are they, among other things, also entitled to citizenship, or at least a reasonable opportunity to be citizens? I would obviously advocate yes, but this is a debate that is yet to be had properly.
Thank you so much. At this point, we have about 15 minutes left for today's panel discussion. And I want to urge, there are some questions already. I want to urge audience members that there is a option available to enter in your questions for the panel. You may address it to any particular panelist, and you may send it over to us, and we will ask it here. I'll pose it for you to the panelists. To start off with, I just wanted to ask these a couple of questions that are coming up. One, I guess this is already in sort of alignment with what Professor Bhatt was mentioning. This is to you, Mr. Raj. This idea of there being a test like the reasonable classification test that supposedly only checks for discrimination or only checks for classification on the basis of some objective that the government itself has put forward. Would you think that in general, this test was not really made for a question like discrimination? And I guess I can supply an example to help out with this, which is that imagine there is a government policy that we want to hire individuals who are, who come for work regularly, who don't miss out on work at all. And don't miss out on work for frivolous reasons, or they generally come to work more often. It might be that as a result of this objective that the government has, that they may suggest that women should not be hired for this particular role, which requires regular coming to work, because they might have various tasks. They might, many of them may end up unable to come to work because of pregnancy. They may have various tasks in relation with this sort of a objective of theirs in society, let's say. They might suggest that all of this taken into account means that their objective requires them to distinguish between men and women. Would that mean that there is something off about the reasonable classification test when it comes to questions of discrimination? can any distinction between one religion and another, or men and women, or one caste or the other, be decided on the basis of an objective that the government has come up with?
Yeah, thanks for the question. I think the question sort of overlaps between reasonable classification and indirect discrimination. So, because the example that you've put forth is overlapping a little bit into indirect discrimination and reasonable classification. So, of course, as Mohsin was rightly pointing out, I think it is true that the jurisprudence on reasonable classification in India is somewhat underdeveloped, and courts have, in fact, at times just looked at whether or not there is a distinction and have accepted that yes, there has been a distinction, and two, looked at what the state's objective is and has not really examined whether the objective that the state is bringing forward is reasonable or not. The courts have often accepted in India the state's version or the state's justification as a justification on the face of it, without looking at whether that's a bona fide justification, that's a malicious justification, or whether that is a justification that is just true in fact, whether that is factually accurate. And it is true that that remains a drawback of the reasonable classification test as such. But I would believe that in the example that you have put forth of saying that women are burdened with a lot of things and hence might be unable to do a lot of tasks, and hence we reserve this position for men whom we are sure will turn up for work, considering the socio-political situation of India, would not fulfill the rational objective test. Even going under this sort of minimalist threshold, it depends on how the court will see it, but I do not think under the traditional reasonable classification and a rational nexus test that it fulfills. The second aspect is that of indirect discrimination, and the facts that you have just narrated reminds me of the facts in Air India versus Nargesh Mirza, which have essentially said that for women who become pregnant are ineligible to work as a hostess, and associating these gender stereotypes with a particular sex. And that's of course problematic in itself, for the Supreme Court partly held, and later the problematic reasoning was overruled in Navdej. The problem is whether when you say that some category of people, be it religious groups or groups of sexual identity or sexual minorities or caste groups, are deprived of something on the one hand, or if you're essentially, or if you're giving away benefits and you're excluding one particular group, the question is on what is the basis on which you're making this distinction, and what is the basis on which you're making this exclusion. Now, if the reason for you to make this exclusion is based on your own gender stereotypes in case of sex discrimination, your own religious bias and prejudice in case of religious discrimination, then these reasons are simply not good enough under constitutional law, going by the jurisprudence on 14 and 15. This is why a lot of sort of commonsensical stereotypes are unacceptable in constitutional law. And this is precisely also why in the Anujkar case, where women were disallowed from being employed in areas where liquor was served, or in areas where or in just bar or wherever alcohol is available. There's a commonsensical view that, of course, it is unsafe for women to go to a commonsensical view for some persons, at least, that it is unsafe for women to work in that kind of environment. And that kind of prejudice and that kind of stereotype just does not hold water. When we say that the state wants to make a classification, the state wants to make this exclusion on the ground that we have certain stereotypes about you, which might be accurate or inaccurate, and even accurate stereotypes, for example, are insufficient to justify exclusion, are insufficient to justify wrongful discrimination.
Thank you so much. This really raises a few questions that actually I can bring back to Professor Bhatt on sort of the inverse of the question that I just asked Ms. Raj. I want to pose to you, Mr. Bhatt. There's this there's this general feeling, this has come up again. I'll combine two questions that have come up somewhat. One is the suggestion that the kind of distinctions that the Citizenship Amendment Act makes, particularly on the grounds of religion, that they are a kind of affirmative action. You can see this is a kind of analogy or a metaphor that is being drawn with the kind of affirmative action that is carried out in relation with reservations, in relation with distinctions on the grounds of caste. This is a kind of affirmative action. If we take it on those lines, would you think that actually there is some reason to believe that tests like reasonable classification play a role there? Because we can't simply go on the grounds of who is a vulnerable group, who has faced substantive inequality, because the claim by the government seems to be that this is the vulnerable group. And these groups are the who have excluded from the CAA. Those groups, in fact, are not vulnerable. In this sense, do you see this controversy raising a question both of substantive equality, where we identify groups that are vulnerable, and of some kind of formal equality, where we have to find out whether all vulnerable groups are being identified the right way and are being treated the same? It's a combination of the two in a way. And secondly, because Ms. Raj mentions it, I'll just add this on. Article 15 already uses this language of stereotyping, which has recently come up in cases related to adultery, related to sexual orientation. These kinds of cases have already, or related to permanent commissions in the army. These kinds of cases have created a test in Article 15 that if you're engaging in stereotyping, then that should be impermissible. It's an impermissible way of using Article 15 grounds. Do you think that a stereotyping related ground is perhaps helpful when it comes to this to assessing the validity of the CAA?
Well, the first question about affirmative action, it's fascinating. We have come across this point, but irrespective of getting into the language of affirmative action or not, as in there's no doubt that there is, I'm being generous to the government here, there's no doubt that there is an attempt to create certain ameliorative laws. Right? These laws are meant to, the sort of public justification is to ameliorate the harsh conditions of persecution, which none of us can deny, that exist unfortunately, in our neighborhood. So we are not going to deny that, say, for example, Hindus and Sikhs face religious persecution in these three countries. And therefore, even if we accept it, one doesn't need to accept the paradigm of affirmative action. We are already in the world of the question of the legitimate boundaries of state action when the state is claiming to engage in ameliorative action. And that story, as far as equality is concerned, is a story of substantive equality. And when we are assessing the question of equality, we will assess both in terms of whether this ameliorative action meets the right kind of classification for its purpose, right? Because I don't think anybody, or maybe there are people, but I definitely will not advocate an argument that the Indian state should never make any distinction based on persecution. The debate over here is not whether the state can use categories like persecution or not. The debate is what is the right way to define persecution and what is the right way to implement it, which does not either discriminate in an invidious sort of manner against people who are also persecuted within that meaning, or second, does not create certain direct or indirect effects which are bad for people who are Indian citizens. So for instance, when I already said that CA 2019 read with 2003 amendment has implications for Indian citizens. Therefore, those implications for Indian citizens cannot be irrelevant to the claim which the government is making that it is ameliorative for non-citizens. Again, what Tulasi pointed out, the fact that if persecution is something that the government wants to ameliorate, then the substance of that persecution and how that persecution may be something which other people have also faced becomes relevant all over again. As in that is how I would sort of respond to the question of substantive equality. Of course, there are some questions coming up around Article 11 and sovereignty, but I'll leave it to you, Lalit, to raise them in time.
To make a quick follow-up on that. Firstly, on this question of stereotyping, I think I could just reiterate that. Would you think that there is a question of stereotyping on the part of the CA's religious discrimination? And just to add on to that, would you say that there are some very difficult questions there to ask about where is the burden of proof really going? Where is it being placed when it comes to figuring out? And what kind of facts really should the court be looking at when it suggests that something is or is not constitutional, making this kind of religious discrimination?
I need to think a bit more about what the stereotyping impact is, because usually when we think about stereotyping, it's usually in the context of gender, which I'm most familiar with. But maybe as in a broader sense, where does the idea of what we call anti-stereotyping principle really come from? It comes from a larger understanding of the purposes of anti-discrimination law. And one argument, at least what I support that account, is that anti-discrimination law is meant to minimize the social context or social conditions of group subordination. And group subordination can happen in a variety of different ways. It can happen through stereotyping. It can happen through taking away valuable liberties by the questions of dignity, by treating certain groups as being inferior to the others. And one of the major and important, and for me, very persuasive argument against CAA is that it violates that particular ideal of anti-subordination. Because what it really shows, and that is how I ended my preliminary comments, that provisions like CA 2019 directly and indirectly entrench the understanding of alien citizenship. That there are some people in your country who may be formal citizens, but are not part of your nation. They are in some sense either outsiders, permanently outsiders, irrespective of their legal status, or they are people who will always be suspected foreigners, always those people who you should be worried about because they are a threat to your national security. Now, that is not a legalistic point, right? The problem of alien citizenship is a sociological, historical problem, and something which may lead to problems of second-class citizenship, of societal discrimination and exclusion. What in my assessment, what 2019 CA does is that it entrenches that idea. It's a way of legally endorsing that view that that certain people, Muslims specifically, are alien citizens. Non-Muslims, if they're coming from outside, can be treated as Indian citizens. After all, India is their homeland. But if they are Muslims, then India is not their homeland, which I guess also applies to Muslims who live within India. Now, that is a slightly nuanced point. That is not an obvious legal point to make. But I think that if we treat CA 2019 and 2003 in the larger context, in the political and social context of citizenship politics in India, I think that conclusion is very difficult not to reach. And once we accept that alien citizenship is a problem, and there's a connection between alien citizenship and 2019 citizenship amendment, I think one can then also make a much stronger anti-subordination argument against the 2019 amendment.
May I say one thing?
Yes, absolutely. Just a quick point. We somewhat run out of time. Yes, but yeah.
Yeah, as Mohsin was saying, it's true that as far as the anti-stereotyping principle is concerned, it's in Indian jurisprudence, it's been applied to sex. But perhaps one of the ways in which the Supreme Court could develop it is by applying it to religion. In the case of CAA, it depends on how much you want to stretch it, and how much you want to and what you want to interpret under the anti-stereotyping principle. So if you can assume that the government's reason for excluding Muslims is a prejudice against Muslims in general, a prejudice and a stereotype that Muslims as a community, or at least Muslims who are not yet citizens, who are in the neighboring countries, are a threat to India's national security. That there are some terrorist affiliations for Muslims for just the fact that they belong to that faith. If that is the stereotype, that is a motivation behind CAA, and if the court is able to gauge that, I would believe there are some reasons for attracting the anti-stereotyping principle into the CAA argumentation and structure altogether, and it depends on how creative the court wants to be about the anti-stereotyping principle. But I think that might be one of the ways to go.
Thank you so much, Ms. Raj. I think we've run out of time. Yes, I think we're past 1 hour 15 minutes. I really hope that our audience on hearing this discussion can take back with them some kind of greater clarity. If the terms on which this debate was being had earlier was at a particular point, because I think at least because of the way our courts have dealt with questions of equality, I can hope that those who have listened to us can get a little bit of an understanding about how better we can push the envelope on this on the discourse that equality or discrimination has in India. The new questions, the sort of ideas that the CAA has brought out for the first time, these questions of alienage, these questions of the substance of the right that is being discriminated on, what it really means to discriminate on a particular ground. I hope this is really clear to our audience, and I thank them very much for joining us. To my two esteemed panelists, Professor Bhatt, Ms. Raj, thank you so much for coming over here. It was great to have a discussion with you, and I love to hear what both of you had to say, and all the best for both of your future ventures. To all present here, with the Vidhi Centre and IIC will be going forward with this year-long series of discussions, really picking out more subject matters like this for future editions of this same discussion of Bridges and Bricks, the Constitution at a Crossroads. We believe that there is a greater speed at which discussions on constitutional change are taking place today, and it's important that we slow down a little bit and we have a little bit of a easy discussion on exactly what are the stakes, what are the consequences of different constitutional choices. So I hope you can all join us for our next edition. Thank you so much, and have a good night. See you next time.
Thank you so much.